Opening act is over. We're now turning it over to the main reason you attended this concert today. We have Alan Schwartzseid, Chuck Nix, two amazing attorneys from our Winter Springs location here at our Kaye Bender Rembaum office. Alan, Chuck, take it away, guys.
Sure. So I'll just give a brief intro. Chuck's going to go through the materials, and then you guys will get our kind of top 15 amendments that people don't talk about, but you really should. So for those of you that don't know the firm, very brief introduction. Kaye Bender Rembaum is a law firm that does nothing but serve community associations. We very rarely will work with individuals. It's 99.9% corporate representation. If your community's happy with your attorney, good for you. Stay there. Have a nice day. If not, we hope you'll consider us after hearing what we've got to say today. You can reach myself or Chuck. You'll get those slides. They'll have our contact information, including email addresses, which is usually the quickest and easiest way to reach us on there. But going through very briefly a little bit about the firm, been around since 1993, 23 attorneys, eight, including myself, who are board certified in this area of law representing community associations. One who is board certified in construction law, who actually runs our litigation team. We've got offices here in Orlando area, which is in Winter Springs, Palm Beach Gardens, Pompano Beach is our main office, another office in Tampa, and as Jeff mentioned, in Miami-Dade County by appointment only. And that's about it. We don't want to waste a lot of your time with information about the firm. We know you're here for the information. So here we go, Chuck. Go ahead and I guess open up the slides, and it'll all be up to you until you're done. But I'll be happy to jump in if I see that there's anything you might have missed.
Will do. Thank you, Jeff and Alan. I'm just going to open up these slides here so we can take a look at those. Can everyone see those slides, Alan?
Yep, you're
Good.
good. Go
Hey,
for
All
it.
right,
we're looking
great.
good.
My name is Chuck Nix. I'm an attorney and have lived in the Orlando area for many, many years. Actually finished high school here, so I'm very familiar with Central Florida. I'm really excited and happy to be with KBR, who I've really respected for years. Statewide firm, has a lot of resources and tons of knowledge in this area. So I'm really excited to be presenting what we call jumping into the present, why updating the governing docs of your association is critically important. And let me move away from our intro slide to our first slide, which is the hierarchy of governing documents. And when we use the word hierarchy, it's referring to the standards that courts implement when they interpret and apply the governing documents. The terms, for instance, the terms of the declaration will control over the terms of the articles of incorporation. And this is particularly important with respect to provisions that are similar or conflict with each other. So for both HOAs and homeowners associations and condominium associations, there is a exact same hierarchy, which goes declaration, sometimes called referred to as the CCRs in homeowners associations, always referred to the declaration in condominium scenarios. And this document is your community's constitution. It is what binds the members in the association. It's the authority on the day-to-day operation of the community or the condominium, whatever you're referring to. And just as another introduction, we'll be referencing statutes as well. The statute for condominiums is under Chapter 718. The chapter for homeowners associations is Chapter 720. And all not-for-profit corporations, whether you're a homeowners association or a condominium association, the corporate entities themselves are governed by Chapter 617, which is the not-for-profit statute of the Florida statutes. So anyway, so you've got your declaration. That's the Constitution. Underneath that is your Articles of Incorporation. This is the document that outlines the structure and the powers of the association itself, the not-for-profit entity that we just discussed. That is the association. Underneath the Articles of Incorporation are your bylaws. This is the document that contains the operating rules for the association. Think the procedural side, such as rules for meetings and the election of directors and officers. So that's the document that will contain a lot of your all of your procedural rules governing the association. And below that is your rules and regulations. These are board-made policies. For instance, we've just been working on a towing policy for a homeowners association client. Three of the things well, one important thing that Alan and I wanted to bring up to you is three items that it takes to have a valid board-made rule. The first element, if you will, is that one, it must be a reasonable rule. Alan, do you have any examples of what might not be you probably have a good real life example of what might not be a reasonable rule that you've had a client come up with in the past?
Yeah, I mean, I've seen, you can't park in your own parking spot. You can't drive through the community to get to your parking spot. I don't understand how that works. But in reality, this is going to be subjectively evaluated. Is it reasonable from the judge's perspective or the jury's perspective is really what we're looking at here. There are specific cases that detail what is an unreasonable rule, but the bottom line is, I think the best criteria you can use is what does your attorney tell you is reasonable and not? My suggestion is always if you're going to adopt new rules, amend your rules, or no one's ever taken a look at your rules, have your attorney just take a quick look, make sure that these rules are going to be enforceable. But that's really it. I don't really know of any specific rule, although there are rules that are illegal, primarily, those that have to do with race, age, and other protected classes and things of that nature. But Chuck, I'll let you get back to the other two elements, and then I had one more point I wanted to add.
Sure. So that first one that Alan just discussed a little bit more detail, that is the reasonability, and the two others is that the rule must be supported by the DEC or the bylaws. We'll say shorten it. Alan and I will DEC, referring to the declaration that we just discussed, or the entity's bylaws, the association's bylaws, and the third reasonable, or the third element, if you will, is that the rule cannot contradict anything in the governing documents themselves. So those are really the three elements that one would need to look for, and we often do when evaluating clients' policies that they come up with. Alan, that was just about it for the slide. If you wanted to add.
Yeah, just the only thing I wanted to add was we talked about condos and HOAs. We didn't really touch on co-ops, and the only thing that's going to change there, the hierarchy is the same. The way that it's going to be evaluated by a judge or a jury is the same. The only thing that's going to change is that primary document, the declaration of condo, declaration of covenants. It's generally going to be a different document. The ownership structure is also different in a co-op, but we're generally going to be looking at that master form proprietary lease as really the declaration for a co-op. I've very rarely seen an actual document called a declaration or covenants, conditions, and restrictions in a co-op. It's usually that master form proprietary lease due to the way that a co-op is laid out. That's all I wanted to add, Chuck.
Right. No, that's a great point, because that helps tie everything in, and really goes to my last point about that this is the hierarchy, just as a reminder, and to keep everyone's thoughts. Sometimes we focus in on things and don't look at the overall, the 40,000 foot perspective, and just this, please recall that this is a hierarchy of the governing docs. We have, as mentioned before, and Alan kind of just mentioned as well, there's statutes 718 and 720 respectively that will, some provisions of the statutes will control over the provisions of the declaration, while others won't, and it's critically important to speak with counsel about that. It's really this is not a webinar to go, we just don't have the time to go into that. That's an entirely other webinar, but wanted to bring that up so you got the overall outlook.
Yeah, that could easily be another half hour to an hour in and of itself.
Right. So we'll move on to the next slide here, which is our amendment process. The amendment process typically is done either in a meeting or in a written approval. It really depends on what the governing docs say. Some governing docs may require member approval. of an amendment via assigned instruments such as a joinder or a petition of a member, while other governing documents in other communities might require passage of an amendment via a member vote at a duly noticed meeting. It really depends on, and you're going to hear that a lot, unfortunately, we're attorneys, so we use the word depends a lot. It just depends on the specifics of each community. The next element that we'd like you to be aware of in the amendment process is your proxy voting. For anyone who doesn't know, a proxy, the term or word proxy is just simply means an authorization to vote on someone else's behalf. It's a written document saying, I authorize this person to vote in some capacity, and we'll go into what those capacities are. You have a general proxy and a specific proxy. A general proxy is like a limited power of attorney. It permits the proxy holder to vote however they want on all issues to be voted on by the owner. So they really have any power in the right to vote yes or no on any of the issues at hand that need to be voted on, versus a specific proxy that's given by an owner to a proxy holder that only authorizes that proxy holder to attend the meeting for quorum purposes, so that there's a minimum number of people, a requisite number of people at the meeting to have it be counted as a meeting for voting purposes, and to complete and submit a voting ballot as directed by the person on whose behalf that proxy holder is appearing to vote. So the unit owner or the homeowner. So the homeowner will tell them, here's the proxy. I am directing you to vote this particular way. You can show up and do that. And that's it. So those are the big differences there. And another important note for this subsection of this slide is that both Chapter 718, the condominium statute, and 720, the homeowners association statutes, permit general proxies for membership votes. However, general proxies are not permitted to elect directors in a condominium alone. So that's a important distinction that we'd like to point out to you. The next subset under our amendment process slide is the distribution to members. Members are entitled, and this really goes back to, I think, constitutional rights and due process. They're entitled by law to copies of any proposed amendments 14 days prior to the date of the meeting. And as Alan and I were discussing this a little bit yesterday, you gave me a great reminder that additionally, if your association is required to maintain a website, copies must be posted there at least 7 days in advance of the meeting. If you're not sure if your association is required to have a website, that's a good question for your counsel. And again, probably a whole nother, I would guess, Alan, topic on those types of things, right? Right. And I think he or I, probably him, will talk a little bit more. When I say we, also, I'm typically referring to our law firm has a robust CLE continuing education courses on its website that Alan and or Jeff can talk more about.
I'm going to do a quick interruption, Chuck. I just want to
Yeah.
mention, Alan, the benefit of having two attorneys on today. Alan's answering some of the questions that are being typed in. So, folks, what you can do is, if you look at the Q&A module and go to the answered part, you'll see the answers to questions that are on topic that Alan is typing in. So back to you
And
guys.
just to be
Sorry.
clear, I'm actually only answering the ones that are not on topic for today.
Oh, okay.
We're going to save the rest for later. We'll see how much extra time we have at the end, but I'm trying to take care of the ones that really we wouldn't be answering in the Q&A. But again, as you mentioned, having two attorneys allows us to take care of some of those, without having to say, sorry, sucks for you, we didn't get to you.
And just a word of caution too. Don't write a novel. Keep your questions short, sweet, and not too association specific, because we don't have your documents in front of us. And one thing that we all forgot to mention, myself included, is nothing today that you hear is to be considered as legal advice. This is all educational in nature. So don't go back to your boards later and say, hey, Chuck and Alan said this during the class. We got to do this. Well, that's not how that works. All right. Back to you guys.
All right.
And just to be clear, I'm actually only answering the ones that are not on topic for today.
All right.
We're going to save the rest for later. We'll see how much extra time we have at the end, but I'm trying to take care of the ones that really we wouldn't be answering in the Q&A. But again, as you mentioned, having two attorneys allows us to take care of some of those, without having to say, sorry, sucks for you, we didn't get to you.
If you hire us, of course, that's how it works, however, just to note that. Okay, so we are at the, yeah, so distribution of members, and then the most important, probably the most important part is your vote tally. And this is completed at a separately called meeting where all of the voting materials are counted. That might include ballots, proxies, and/or consents. And we have a note that these are all official records of the association. So the process is very important, and you should note that as such, that the legislature has deemed that a lot of these elements are very, very important to the members, as their rights as owners, of the community or condominium association. So that's our vote tally. So we're gonna stay on this slide, but move into what we consider at least some of, and it expands almost daily is what we, I think, and Alan can probably talk about that a little bit more, what we consider to be material amendments, and we're gonna go over a couple of them. But I think our global or overall comment on this is that you have to look at the nature of the amendment first. If it's an amendment that to correct a minor mistake or a missing, like a scrivener's, what we would call scrivener's error, that's like a missing word that everyone would know by reading the sentence what it was supposed to be there, and maybe can't really interpret that much, or there's a spelling error. Little smaller errors don't necessarily always need the vote of the members. Typically, they don't. Another example might be an emergency maintenance expenditure of funds, where the directors just have to spend money to get something fixed in order to prevent more damage from occurring. These are things that are often written into the declarations that will permit the board to make the decision without a vote of the members. However, most amendments are going to be more substantive in nature. And if there's any material or substantive change, that the amendment typically will need a vote of the members. And I came up with a crazy example of annexing additional property into the association, but there's a lot more than that. I would probably say it's most amendments or Alan, would that be, you think,
Yeah, I
correct
mean,
assumption is?
unless it's correcting a scrivener's error, almost any amendment is going to be a material one.
Right. So, but there is a distinction that we think it's important for you to note. And again, continuing theme is it depends on what your governing documents say. The next one is termination of an association. This would be, if under condominiums, it's actually in the statutes, termination of the condominium, which is actually ending the statutory regime that created the condominium association, and then in terminating all of its powers and then winding up the affairs of the association. This type of action requires a huge supermajority vote, usually 100% of the members. Oftentimes, yeah, at the very least, it's a very high supermajority. So the next one that we wanted to bring up is leasing and rental provisions, if any. The first comment on this being that this is a pretty important area and asked a lot. So I believe we have a specific class covering just this topic, right, Alan?
We do, and we probably have on our website about 10 different recordings by different attorneys, probably 3 of them by me alone. So yeah, that's one that I mean, especially it's 11:25. We're not going to get into that right now, but it is something that's important. So the bottom line, really what you need to know is that not everything is going to be, not every amendment, especially regarding leasing and rentals, is going to be one that everyone in the community is subjected to. There are certain things that you can do in an HOA in particular to make everyone subject to that particular amendment. But generally speaking, it's only going to be the people that bought in after the amendment or voted for it who are subject to a leasing or rental restriction.
Right.
Chuck, all you.
Next one is your suspension of voting rights, and we wanted to point out here, if the right to suspend the voting rights is not in the governing documents, the board does not have the right to suspend member voting rights. The last one we'll point out here is the mortgagee approval clauses. Very often, and by statute, in fact, but it's also will also be covered in the declaration, and if it's not, you should discuss with counsel, is mortgagee approval of amendments. In both of them, it's really any amendment that might adversely affect the priority of that lender's lien. You would need to obtain mortgagee or lender consent for any amendment that affects their rights. Or in a condo, I have, or that otherwise material affects the mortgagee's rights and interest. That's really going to be, I'm looking at both 718 and 720 share that same language. So you should start thinking about that if you see that the amendment, proposed amendment, may affect the rights of a lender or the priority of their lien. Okay. And any amendment adopted without the required mortgagee consent is voidable by the mortgagee, who's entitled to notice and an opportunity to consent to that amendment. So that can be a very, very important point, and possibly delay approval of amendments. We're going to move to the next slide.
The other thing that is in the
well,
slide, but you didn't really mention, was the time frame when, if someone is going to challenge an amendment, they have to actually file that lawsuit. Now, there used to be case law that basically said that, if you buy in, you've got 5 years to challenge that amendment. Nope. You've got 5 years from the date of recording. So sometimes I will give intentionally bad advice and say, this is not what I would recommend doing. But if you choose to do it anyway and you adopt and record this amendment, people only have 5 years to challenge it. So if you don't think it's going to be challenged within the next 5 years, you might take the risk. Because keep in mind, as lawyers, it's not our job to decide what the association can and can't do. It's our job to outline what the risk is if you do it wrong. So there will be times where I don't advocate for it by any means, but I'll mention it as a bad option. And if the board chooses to take that bad option, that's their prerogative. All right. Thanks, Chuck.
Yeah, no, that's a great point, and obviously it's right there on the left of the slide, and so thanks for covering that. So extremely important point, particularly for us as we're thinking about things here in the office for clients, and strategy and ways to move forward in the best way and in the association's best interest. Next slide is your common misconceptions slide. So what provisions are illegal? Lots, and we kind of touched on this a little bit earlier, kind of, sort of, but rate provisions that might be illegal are areas that deal with your race, age, one's disability, religion, ethnicity, family status, country of origin are some of the big ones. One that we have seen really start to increase in popularity is not the right word, but increase it as just a general issue is the age. And it's not the way I think that most listeners might think about it. It's actually with regard to age restrictions on the use of amenities for minors and how that might be too restrictive. It also, age might play a role here in the 55 plus, the age restricted communities, where owners or members are required by law or situations of life to be the caretakers for minor children, who have to then live in that community. Their parents are deceased, or what, a million different things could have happened, but very interesting area of the law, and again, kind of goes into some constitutionality there. A very important area, extremely important to talk to counsel about. and to be mindful of. So what provisions are holding you back or costing you money? This is another great area to discuss. Lack of so this is what may not be in your governing documents, particularly your declaration, that you may want to think about amending to make your association more financially feasible and to bring in more funds, which at the end of the day really is the way the world works, as we all know. So one is lack of late fees. If you do not, if the declaration or your governing documents do not provide for the charging of late fees, the statute says they cannot be charged to the owners. So they must be, late fees must be in your governing docs. The governing docs could have a low interest rate charged on late assessment payments. Typically you'll want to charge upwards of the maximum amount permitted by law, if you know, which is anything under the usurious rates of interest, which is typically 18% per annum in the state of Florida. Again, talk to your counsel about the specifics of these. We're bringing them up as the big points and ideas for you to understand. Another,
said 15%.
Yeah, please
it's
go.
actually 18.
Sorry, Alan.
I think you said 15%, but the interest rate on
18%.
assessments in particular. Oh, you did say 18. Okay.
Yeah,
I'm sorry.
If I 18 in Florida per simple per annum, not compounded. The another one is I potentially looking to modify or the lack of a modified safe harbor provision. I don't know, Alan, am I even saying that right? To further protect the association.
Yeah, it would be to modify what happens when a lender forecloses,
right,
and is generally entitled to pay nothing to the association. What you can change it to, usually only for future recorded mortgages, because there's already a right of these lenders to say we relied on this provision in giving the mortgage in the first place. But you can change it to say only the lender is protected, not any third party purchaser. And the amount of the assessments that are written off, so to speak, is limited to what's in the condo statute, the HOA statute, or the co-op statute, which is, usually 1 year of unpaid assessments or 1% of the original mortgage debt, whichever is less. The difference is what most declarations provide in order to incentivize lending in communities is that the lender pays nothing, and possibly not even a third party purchaser pays anything toward those pre-transfer assessments, meaning before the lender actually got ownership of the property. And so what Chuck is suggesting is, you can make that a little less onerous on the association. If a lender forecloses, they still have to pay some portion of the unpaid balance that was owed from the former owner, is really what we're suggesting.
Right. Another, thanks, Alan. I appreciate that. Sure. Another kind of idea that you might want to think about, or something that you see that can be amended in your declaration that might save the association some money, or over maintenance or other requirements that overbearing requirements on the association, costly, that no longer fit the nature of the community. Ridiculous landscaping, upkeep, maintenance requirements, for instance. Some of the onus may be able to be put on the owners. Some of it may be able to be taken out. Just some examples in what are some of the provisions in the declaration to get the brain juices flowing as to what we can help fix to make the association run more smoothly, more efficiently, and at less cost. Next, so we're now in that.
So
that's
Chuck,
kind of
I don't mean to
really,
cut you off, but we're more than halfway through, so I think we're probably going to have to skip the provisions that, frankly, I don't love the examples in here.
Okay.
Either that or kind of blitz through them so that we do get through them. So if you want to go through them real quick, I have no problem with that, but I want to make sure that everyone gets a little bit of time for Q&A, and that I can run through the list of things that I think everyone should be considering as amendments. So if you want to blitz through this, feel free, but that's up to you.
Okay, we'll quickly go through these provisions. I'll move these over here and you can see them and let us go to Q&A. So the first one states that a foreclosing lender is required to pay 1% or 12 months of delinquent assessments. We just went over that. That's false. The governing docs may contain language providing the lenders with greater protections. The second one is landscape grass lawns must cover the bulk of the front yards in our HOA. Again, that is false, and this is a incorrect reference in the statutory sections, but it's section 720.3075 discusses Florida-friendly landscaping, which has issues of its own, and we can discuss that probably another course or with us afterwards. The next one is the board has sole decision-making power when it comes to filing lawsuits. That one is mostly false. Interestingly, the big one for you is the Florida statutes prohibit commencing litigation against any party where the amount in controversy is 100,000 or more. You need a member vote that. So this one goes to leases or buying. All new owners go through the screening process in our community. False. Many of the mortgagee protection clauses that we discussed prohibit the association from screening anyone. So another good reason to get a full review of your governing docs from
Hey, Chuck, I got to interrupt, my man. I got to interrupt. We lost your slides. I think we have it on the wrong input.
Oh, okay. Sorry.
We're getting it up, guys. Thanks for pointing it out.
I'm sorry.
There we go. And folks, you're going to get the slides afterwards. I know some of your monitor ratios, it looks a little smaller, but you're going to be able to download a copy and save these afterwards. Chuck, back to you, sir.
Yep, I'm sorry about that. The board has sole decision-making power when it comes to filing lawsuits. We discussed that. Screening process. Once the law changes, the change is automatically applicable to your community. Again, false. We discussed that a little bit earlier. There are instances where the law will apply if the law is procedural or remedial in nature. However, the law cannot change fundamental contract rights.
So that's Kaufman.
I'm sorry.
I said that is Kaufman in a nutshell.
Right.
And we'll go through that when I get to the Q&A, but yeah, that's what we call a Kaufman analysis, is their language that adopts future changes to the statutes or not.
Another good example is people always say residents are prohibited from having clotheslines in the HOA, and that's false. Because they'll fall under an energy saving or renewable resources device, clotheslines, solar panels, etc. There's statutory language authorizing those.
Yeah, and keep in mind, there are a lot of statutes that are not related to HOAs and condos that still apply to HOAs and condos.
Right.
So along those lines, you've got the Fair Housing Act. We've got a class on that. You've got certain over-the-air device rules regarding satellite dishes and things of that nature. You've got, like Chuck mentioned, the solar panels and energy-saving devices, Florida-friendly landscaping. All these things have nothing to do with an HOA, but they apply to an HOA and a condo anyway.
Trespassing by strangers, and if you have a wooded area, we deal with that a lot, and that's under the criminal stat in the 700s, that's as another example. Our community can enforce rules prohibiting minors from using any of the recreational facilities without an adult present, one we just talked about. Federal and state housing laws prohibit discrimination against families with children. The board must obtain a vote of the owners before making any material alterations. And we already discussed that. For instance, the necessary maintenance, emergency exception. Delinquent assessments accrue interest at the rate of 18%. We learned that's not true. If your governing documents say 9%, how can they accrue at 18%? Look at your docs, get them amended if needed and wanted. Last one, a pipe in a wall serving one unit is a maintenance responsibility of that owner. It just depends on what your docs say. And we already went over those two slides. So I think that was it. I just wanted to go over those quickly because I think they have some good real life examples, some of which we didn't necessarily go over. So
agreed. I appreciate it. All right. So thanks, Chuck. I'm going to run through and feel free to chip in like I did if you've got any thoughts of what I might be missing once I get through
Okay.
everything. But some of the things that I consider the standard, hey, you should probably look at this type of amendments that no one seems to be talking about. The first one, and there was a question in the Q&A on this, amending the amendment provision to make future amendments easier. If you haven't thought about, hey, let's start with an amendment to the amendment provision, that's usually going to be most useful when you've got a group of people that want to make changes, but they're not enough to make those changes. For example, the declaration says you need a 2/3 of the members to vote in order to adopt any amendments. Okay, well, start with an amendment that does nothing other than reduce that to a majority or 2/3 of a quorum. Reduce the quorum provision. These are just amendments that we will customarily start with if the board really wants to make some changes but doesn't think they can get them passed. Start with that, push really hard for that one, and you won't have to push as hard for all the other amendments, the substantive ones that you really wanted to work on in the first place. Another thing that we do that I don't really see other firms suggesting or offering, a consolidated declaration. So you've got your declaration, you've got your First Amendment, you've got a supplement, you've got 28 more amendments because the developer doesn't care enough to clean this up and make it neat before they transfer it over to you, because that'll cost them more money and they'll be out at some point and not really have to be involved in the operation of this community. But you and your attorney are going to have to read those 28 amendments in order to make sure you're getting it right every single time. We can shove everything into one document. The board gets to decide whether or not to do this. The board gets to vote on it. This is not an amendment. It's not changing anything. It's putting everything into one document that is after that, once it's recorded, once it's done, it's all you have to look at so that you don't have to read through 15 different documents. Frankly, my perspective is once you hit 5 supplements, amendments, or whatever you want to call it, you should be doing this every single time. Either a consolidated declaration if you don't think you can get amendments passed, or an amended and restated declaration the next time you're trying to work on amendments. They serve the same purpose. It's to put everything together, make it comprehensive and easier to read, and frankly, make it less time consuming. The cost of doing this tends to save the association money after the first 6 months after it's done, if you've got any meaningful legal work to be done. Making this is another important one. When you do your covenant enforcement work, a lot of people look at that as a cost of doing business. They don't want to send it to an attorney because it costs money and they don't think they'll ever get it back. And in a lot of instances, they're absolutely right. Most declarations don't allow you to recover the fees and costs incurred in enforcement unless you actually file your lawsuit. So that first or second letter that you send before you file that lawsuit, the cost of going to mediation, which is a statutory requirement for covenant enforcement in condos and HOAs, that's all just gone unless you reach a settlement with the owner. Well, not if you amend your declaration. So the way that I usually will recommend it is, first of all, you make it so that the association's entitled to recover those fees and costs, regardless of whether a lawsuit is filed, as long as there was a violation. And almost more importantly, you're entitled to recover those fees and costs as an assessment against the lot. Just like you were going onto the lot and curing the violation yourself, you're entitled to recover them as an assessment. What that accomplishes is getting it off the plate of all of the members to share in this cost that you otherwise might not recover. Because let's be honest, a judgment is a nice piece of paper that says this owner owes you money. Whether you're going to actually collect on it might be a different story. Okay, but if it's an assessment, you send a notice of late assessment, you go through your customary collection process, and all the fees and costs incurred collecting that assessment are also automatically recoverable. So you're making it, instead of a cost of doing business, you're putting the responsibility for what was charged eventually onto the owner that caused that problem. Okay. And usually the way that we'll do it is the assessment is due either when the violation's cured if it's pre-suit, or when the association gets a judgment saying there was a violation and the association's the prevailing party if a lawsuit was filed. So that's number 3. Number 4, self-help. Terrible. Get rid of it. Okay. Unless you're actually willing, to go onto someone's property, risk that, let's be honest, we're in Florida, you might have your vendor get shot. At minimum, they might get screamed at, physically assaulted, whatever. Okay. Instead of doing that, or risking that you're going to have a vendor go onto the property and cause damage to someone's property and end up with a liability claim. Instead of doing all that, leave a carve out in your declaration for just the really basic things. We're going to repaint your mailbox because we can easily get out of there and go onto a side street and just run basically if an owner comes out threatening the vendor. Okay, we're going to do the innocuous things, but we're going to take out the right to do everything else. The reason for that is that if you've got that right, you have that obligation, whether the declaration says may, meaning it's permissive, or says you must go onto the property. Okay, the statute and I'm sorry, the case law in Florida is very clear that regardless of what risks I just explained, those risks are considered too speculative, I think is the word that the case law actually uses to justify not at least going out and trying it if you've got that right before you try and pursue getting an injunction in a lawsuit. So I would recommend if you can get rid of self-help, get rid of it. Okay. Eliminating Kaufman language. I mentioned this earlier. Chuck mentioned it earlier. This is that language in a declaration, and it's rare in an HOA, a little less rare in a condo. I'd say about half of condos have this language, but it's language incorporating the Florida statutes or the condo or HOA Act, whichever one applies to your community. And this is the magic language as amended from time to time. What that means, if it's in your declaration, is that any change to the Florida statutes is going to apply to your community. Now, Chuck mentioned earlier, if you don't have this language, then you haven't agreed that every single statutory change is going to apply to your community. You've got an existing contract. You've got the declaration. Okay, that's the contract between the members, the people that come into your community, and the association, the corporation itself. If the legislature tries to tell you that contract is no longer valid, that is an unconstitutional act by the legislature. Okay. And that's not just me saying, no, that's not fair. That's not a libertarian saying this is a political issue. This is Florida case law. So keep in mind, if you want to challenge that legislation, in fact, you might need to take that up to the Florida Supreme Court. But the bottom line is, if you've got Kaufman language, you can take it out, and the statutes only as they exist on the date that you take it out will apply. Now, again, Chuck mentioned we could go through Kaufman for 45 minutes, so I'll leave it at that. But my suggestion is if you've got that Kaufman language, consider taking it out, because in reality, everything the legislature has done to condos, HOAs, and co-ops over the last few years may be well-intentioned, but all it's done in reality is harm these communities for the most part. There have been some really good changes, and there have been some necessary changes, but there have been a lot of changes that basically try to take away rights from condos and HOAs. And if you don't want those rights taken away, get that Kaufman language out of your documents. Chuck already mentioned including the maximum statutorily allowed late fees and interest when it comes to unpaid or late paid assessments, the safe harbor, making sure that that eliminates as little as possible when a lender forecloses, allowing for suspension of voting rights. Chuck also mentioned if that's not in your declaration, you can't do it. More that are not mentioned so far today, adding or increasing a capital contribution in an HOA. In a condo, there's been a decision by the DBPR that this is not supposed to happen. Our opinion as a law firm is that that opinion misinterpreted the statute that was really governing only having a certain amount of charges for the application process itself. But a resale or capital contribution is basically, I call it free money that you use for your operating expenses that everyone that buys into your community needs to pay to the association. Adding or modifying rights of first refusal on sales and leasing. Again, I would suggest, as Chuck mentioned, we've got that leasing webinar. I would check that one out to hear more about that particular subject. And I apologize that I'm blitzing through this, but it's already 11:48 and I want to get through all the suggestions. Providing for security deposits for work that's going to be performed in the community or tenants that are going to be in the community. A lot of communities have this. The important part is that they don't have a process of who gets that money back after that lease is done, after the construction is done. And I've actually had several clients that didn't listen to this suggestion and ended up having to file what's called an interpleader lawsuit because they were told by both sides, you need to give me that back, that money, it's mine. And when you have those demands coming from both ends and you don't have a clear provision that says who's supposed to get that money, you're risking being sued by either one if you give the money to either one, or both if you don't give the money to anyone. So you have to file that interpleader lawsuit and let a judge decide, hey, I don't know who gets this money. Judge, the court takes this money and distributes it once this case is over, but I'm going to file the lawsuit, serve the parties, ask to be dismissed, and ask for my fees and costs back. The problem is if that deposit isn't significant, let's say it's not at least 5 to 10 grand, you're not getting all the fees and costs back just from the deposit. So the deposit is gone once you file this interpleader, and you're asking those parties and trying to collect from both of them. Not a good idea. But if you've got a clear provision that says who gets that money back, you don't need to worry about the interpleader. You follow the declaration. We talked about adjusting the quorum and amendment votes, changing the insurance provision. This is another one that people don't seem to think about. Make the association the insurance trustee if there's an insurance claim. Stop paying banks on a regular basis to do nothing. Keep that money with the association. Prohibiting certain sex offenders from residing in your community is another popular amendment. Authorizing amendments by the board to enable people to get loans or insurance, even if other amendments would normally require an owner vote. This is an amendment that we recently started working on, and it's been pretty popular to make sure that people can actually get loans. Their Fannie and Freddie have upped their standards, especially in condo land. And in reality, you want to make it so that people in your community can get a loan. Now, another important thing that you need to do in order to make sure that people can get loans is collect unpaid assessments when they're not paid. But this amendment might be able to help the association in that respect as well. There are a couple condo specific ones that we talk about: defining common elements, what the unit is, and limited common elements. I've seen a lot of declarations recently that are relatively older and don't actually say who's responsible for maintaining what. They say the association maintains the common elements, the members maintain the unit, but don't define what those things are. So making sure it's clear who maintains what, including the windows, the surrounding materials. A lot of times it'll say the windows and doors are an association responsibility. But what about the area between the window and the actual wall? Whose responsibility is this? Those are the areas where you're generally going to have water seeping through if there is any kind of leak. So those are the areas that are almost more important than the window itself to figure out who maintains it, because that's who's going to be responsible if there is a leak. And then finally, no soliciting, prohibiting vendors who solicit from working in the community so that you don't have people just walking around your community trying to get free work. Now, there are probably 10 more that we could add to this list. It's constantly growing and shifting. One that we've recently started adding in HOAs in particular is what I call a catch-all architectural review provision. We've kind of crafted this over the last year or so, but it's essentially a provision that lists every single thing that your architectural review committee might want to adopt rules and specifications, color schemes, materials, things of that nature for. And it basically just says, if you want to adopt it, go ahead and adopt it. Because as Chuck mentioned earlier, if you want an enforceable rule, it's got to be authorized in the declaration. And if you've got restrictions that, say, well, you can't have a white picket fence in your community. Okay, what provision of the declaration authorizes that? If you don't have one, that provision might not be enforceable, even though it's in your rules. So this catch-all basically says, yeah, the architectural review committee can do whatever they want when it comes to adopting these rules. The other thing, make it so the board and not the ARC actually adopts those criteria. The frequency that I see this committee getting to decide what goes on, that has really no one holding anything over their heads, because they're going to hold the association and the board responsible if the ARC makes a mistake. Make sure it's the board that gets to make those decisions, in my opinion, and that's another amendment you could consider. So that's the list for now. We'll jump into the Q&A, or at least what's left of it. Looks like we only have 11 questions right now, so we should be able to get through all of them. Chuck, if you want to see which ones you're comfortable handling, I'll let you jump in, and then if I have anything to add, I can do that, or we can kind of switch off, however you want to play it.
Yeah, why don't you take the first one, because I
Sure.
think you'll be better at answering Suzanne's
Oh, well, we kind of
question.
already touched on that.
Did,
It's
did
how
you?
to
That's
change
what
the
I
percentage
thought, but
of votes.
that's why I wasn't sure.
Yeah, lots of confusion as to how this should be done. It's an amendment. That's how that
That's
needs
what
to be
I,
done, Suzanne. And the question, just for anyone that's not reading the Q&A, would appreciate touching on how to change the percentage of votes to actually rewrite the documents, meaning to adopt those amendments. That needs to be done via an amendment in and of itself, but it can be a separate amendment from anything
right.
else substantive that you're trying to change.
Uh,
Can
from
Go
from
ahead, Chuck.
Anthony, he's asking about amendment to cap the number of rental homes allowed in an HOA community. And that's a really good question because, I don't know the answer. Maybe Alan will correct me. I know that you can cap the amount of homes that an owner can own within the community, but I don't know that it would be fair to just say there can only be X number of rental homes because that might be unfair to some of the owners wanting a rental home. I'm
Yeah,
not,
and my answer to that is sucks for them. Um,
okay,
there's nothing that says you can't do that. The one thing to keep in mind, though, as Chuck mentioned earlier, you do need to make sure that you're not trying to push that on people that didn't vote in favor of it and didn't buy in after the amendment, because
right,
that's one of those that will not apply without one of those two conditions.
right,
So it's
okay,
not, you can't rent anymore. If it pertains to leasing, it's, well, no one else can buy in. If you already own a lot or a unit, you might not be subject to that amendment, but it is certainly one that can be done
right.
and it'll be enforceable. Any amendment can be done, but moving forward, it would be enforceable, is my answer.
The next one from Dennis. I'm not exactly sure I understand the question. The owner passes all of its right to the lessee, but can you charge a different price for golf access? If the
Yeah, it
dog,
sounds from what I'm reading like the question is whether you can charge a higher rate for tenants than you charge for owners for use to association amenities. And I'm not aware of any way to do that other than by having, I mean, here's the problem. Presumably, in almost every lease, the owner gives up their right to use those amenities. So even if you had and a part made that part of the assessment, I don't know that you could charge the tenant a greater fee for that. I don't think that would pass muster, although I'm not aware of any specific case that says you can't do it.
Here's a Pedro Martinez curveball. All right.
Okay.
Not a big old curveball. What if it's the type of community with a golf course, using this example, that allows the outside public to come in and they're technically not an owner either? Is that the same thing or is that different?
Yeah, I think the fact that they're taking over the owner's rights pursuant to the lease
right.
means that they are treated the same as the owner for this particular purpose.
I just wanted to head that question off at the
Yep.
pass. Back to you.
No. Very logical question. Thanks, Jeff.
Thanks, Jeff. The next one from Paul. Alan just pretty much answered, and Paul's asking, saying that their governing docs don't have Kaufman language, and he thinks, is it an advantage not to have the Kaufman language, as he would like to leave it out when they make amendments, and absolutely, I think that's really a business decision that unless Alan corrects me, that the association should make with its council. I don't think you have, nor should you have to include Kaufman language in your amendments. But
Honestly, with what's gone on in the legislature over the last few years, I think it would actually potentially be a breach to include Kaufman language. You're basically
okay,
guaranteeing that certain rights are attempted to be taken from the association by
right,
including it at this point. Now, you can include it in certain aspects of the operation. But keep in mind,
right,
any procedures that have changed, Kaufman doesn't matter when it comes to procedural changes to the statute. It's only substantive changes. And I don't have time to go through what that means, but an example of each one of those, a procedural changes, the legislature has decided you need to go through this ridiculous process before you can fine or suspend someone's use rights in the community. Okay. That's a procedural change. It's not changing whether you can fine or not. It's changing how you do it. So that's the difference. The voting right, or I'm sorry, the fining right in and of itself would be a substantive right. But the procedure is what will apply regardless of whether you have Kaufman language or not. All right, moving on, unless you have anything to add, Chuck.
no. Larry asked about requiring a limit on credit rating. I assume this is for tenants. Maybe it's for buyers too, but
Should be.
for tenants, we've actually dealt with this, and it's our recommendation that It's our advice that putting a credit rating limit on in a tenant application could subject the association to litigation. And I think
Yeah.
Alan can probably expound on that better than
Sure.
I can.
It's in reality, it's a potential fair housing issue
Right.
because, you've got the argument, whether accurate or not, that there is a disparate impact on creditworthiness of different races within this country. And so essentially, there are people that will argue, I don't have this credit rating because of my race somehow. And as a result, you telling me that I can't live in this community or I can't buy in this community because of my creditworthiness is somehow discriminatory. Now, our response to that is, as an owner, we're trying to make sure that you can afford to live in this community. And as a tenant, we're trying to make sure that you can afford to pay the assessments, which you're obligated to pay if we send a demand if the owner doesn't pay them. So there is a basis to do this, but don't think that it's without any risk, is really what Chuck is saying, and I agree with him.
That's right. That's right. And remember that we're not here, and there's really not a lot of things that tell you that you can or can't do things, but there are things that will get you in legal hot water, and we'll leave it at that. When I say you, I mean the association. Um, Moving along, Phyllis and William have really the same question. HOA roofs and solar panels.
Yeah, so there's a
Um,
specific case that talks about this, and Chuck, sorry to jump in. I
yeah,
just
you
wasn't
go.
sure if
You
you were
know
aware
this
of
one
it.
better than I would, anyways.
But there is in a condo, a co-op, or an HOA, regardless of whether the association maintains the roofs, you have to allow the solar panels according to the statute that Chuck
Right.
mentioned. What you can do, however, and what I've historically done in the past, is to require that the person installing those solar panels prove that it won't cause damage to the neighboring units, prove that it won't cause damage to anything else that the association maintains, and sign an agreement that if it does cause any of that damage, then they are going to be responsible for it. In addition to, let's say, I've had one community that we represent out in Tampa where this would actually violate the warranty on the roof itself. They're going to verify with the vendor that it won't violate the warranty, and they'll agree to be responsible as an assessment for any expense associated with the loss of the warranty or the increase in the expense of the warranty. So there's a lot that you can do, but simply saying no is a very risky endeavor, is really the bottom line with respect to Phyllis and Williams' questions.
Then Bonnie asked, can the revised CC&Rs contain at the discretion of the ARC? It's kind of too general of a question that we kind of need to know where, but I think generally speaking, you don't want the ARC to have any and all discretion that it wants, right, Alan?
Yeah, I mean, I would generally want most of the discretion to be with the board. The ARC's
Right.
responsibility is supposed to be primarily limited to deciding whether an application actually meets the existing specs.
That's right.
And if the answer is yes, they're supposed to say yes. If the answer is no, they're supposed to say no. And now, according to Florida law, also tell you why the answer is no. What provision of the governing documents or the architectural criteria says no. The other thing to keep in mind is if you say, at the discretion of the ARC is generally not getting legal guidance when they are amending those architectural criteria. And the Florida statutes, at least governing HOAs, where I know Bonnie is located, actually is pretty specific as to the authority to create those rules needs to be clearly stated or reasonably inferred, is the statutory language, either in the declaration or the architectural review criteria. Now, keep in mind, those criteria also need to be authorized by the declaration, like we mentioned earlier. So if the architectural review committee is just unilaterally, I hate to use the term willy-nilly, but if they're allowed to make whatever changes they want and they're not allowed to consult with the attorney because that would cost money, you're putting the association at significant risk. So again, I would suggest turning that back to the board or authorizing the architectural review committee to confer with counsel before making any amendments to the criteria. And I see Emmanuel has a question regarding dictating service dogs and how they're dealt with. We have a whole separate fair housing class that pertains specifically to service and support animals That's not going to be the topic today, and I would suggest taking that class. Lee asks, what's required to take out Kaufman language? An amendment. Whatever the vote is required for your community for an amendment to the document that it's in, that's what's required. That's it. Chuck, you want to take back over on Karen? Sorry, I jumped in there.
That's okay. Karen asked, do capital contributions have to be used for operating costs? Can they be used instead of a special assessment for mold remediation? I actually
That would
thought,
be an operating cost. So
yeah,
yes.
that's what that said, yes, yes. Didn't Denise asked, didn't the legislature make banning solicitors illegal?
No, it made
Yeah, I don't think so.
refusing a vendor because they're not licensed or insured illegal.
Hey, folks, quick interruption. I have a couple of people asking where are these questions coming from? Alan answered some of them earlier during the class. He typed them in. Those show up in the answered questions. Now, from the same module, questions you are all submitting, they're just answering them aloud. That's why you see some of them answered in the module, and some of them are not answered in the module. They're just answering them verbally right now. So I hope that clears it all up. This recording will be available to rewatch on the firm's website within a couple of days or so under the resources tab in the main menu. Back to you guys.
And to clarify, that module is the thing that says Q&A at the bottom of your screen. So that's where the questions are coming from. We're just scrolling through and answering one by one. Chuck, you want to jump into Danya's question?
Dania says, how should we address a situation where a homeowner who purchased their property years prior to the adoption of amendment restricting sex offenders in the community is later convicted of a crime requiring sex offender registration?
Well, the amendment generally wouldn't restrict who's allowed to own a home in your community, which is what this person already does. It might restrict who can reside in that community. And frankly, if your policy, your amendment is drafted appropriately, that amendment is going to actually match the language of the statute as to where this person is allowed to be, where they're allowed to reside. So you might just call the police and tell them you happen to know that the individual is residing in a place where they're not allowed to be according to the statute, even ignoring the amendment, and let the police do your job for you instead of paying an attorney to do the enforcement work. And Deborah asked, if the declaration doesn't contain Kaufman language, do you recommend adding it?
Yeah,
I
I've already answered
clear
that.
the answer is no. Can you remove it? Jeanette asks. Yes, you can remove it. Kaufman or not, we have to follow the legislature only. Absolutely incorrect, Lisa. I'm sorry to put it that way, but no, the legislature is not the only thing that you follow. Your attorney should be giving you guidance as to whether the legislation or your governing documents apply. You can choose to apply the statute. That might mean you're doing it wrong. It also might mean that you're giving up rights you don't have to give up. Do you agree that a credit score will lead to a lawsuit on credit score for a buyer? No, I believe that it's a possibility. Do I believe that it will? That depends on who the buyer is and how litigious they happen to be. And again, we've been pretty clear that that is not an automatic loss for the association. It is a valid basis to make sure that the people that live in your community can pay their assessments. But that doesn't mean you won't get sued anyway. Chuck, you want to jump in with William's question?
Sure, yeah, this is an interesting one. Regarding clotheslines, must HOAs approve clotheslines regardless of location? Can HOAs disapprove these in the front yard? I think the answer would be yes, you can restrict it as to the location. Unless maybe that location would be in a place that would prevent the clothesline from doing its job, like only in a shaded area might be an issue. I don't, but I think generally speaking, and I'll let Alan correct me, an association can dictate where, just not that they can or not put it up.
The only other thing I'll add is that I think this question might be in line with the changes that were made 2 and 3 years ago, respectively, with respect to installing things that are in view from the frontage of the lot,
Right.
from an adjacent lot, etc. So there are really 2 issues here. One is what Chuck mentioned, which is you can govern the location of this clothesline, but you can't say you're not allowed, or you shouldn't say, according to Florida law, you're not allowed to install it. But putting it right in front, that is something that I have no qualms in saying If it's restricted and it's prohibited under your governing documents or your rules and regulations, go ahead and enforce it, because there's nothing that says that you have to allow people to install it in plain view.
That's right.
Artificial turf. And Jeff, I'm going to jump in real quick just because um, Jeff or Chuck, actually, I'm going to jump in because Jeff mentioned we have
Please.
like 3 minutes left.
Yep.
You'll see how I usually do these Q&As, which is to blitz. So I'm going to handle as many of these as I can before we run out of time. I'm going to stick around until 12:15. We'll see how many we can get through between now and then.
Yeah,
Anita.
that sounds good. They're
All
good
right.
questions, people. Thank you.
All right. Anita, good to see you. How about artificial turf installed in yards? Do we need to allow it? The answer to me is this is not Florida friendly. It is actually problematic because it kills your drainage. And so what you would say is it's not the turf itself that you're enforcing against, it's the resulting drainage problems that you're actually enforcing, so that no one can argue that the rule that says they can install this garbage is going to allow them to do it. The other thing that you can argue, again, unless you've got the Kaufman language in your declaration, this is a substantive amendment to the Florida statutes, doesn't apply to your community, which already prevented people from installing these things. Denise asks, can you charge a surcharge to renters for living in the golf community? We can't charge them extra. No, not same answer. Sorry. That's not probably going to work, although I'm not aware of any specific law that says that it's not allowed. I'm just not allowed. I'm not aware of anything that allows it. Curtis, earlier we mentioned capital contributions from new buyers. Is there a difference between HOAs and condos as to who can charge this fee? What I mentioned, and I understand you were out for a moment, what I mentioned is that there is a difference according to DBPR, but not according to our firm. So there's a statute that limits what you can charge purchasers and renters for entering into your condo complex. This doesn't exist in HOA land. So the HOA statute doesn't restrict this at all. Condos, that statute basically says you can only charge up to $250 for the application process. And a lot of people, including DBPR, have at least once interpreted this to mean that you can only charge that. You can't charge a capital contribution at all in a condo or a co-op. We disagree. So that's the best answer I can give you. The more important answer that I can give you is my suggestion: get a written piece of advice from counsel so that you can rely on that written guidance as the basis to, basically defend any claims that are raised against the association or against you as an individual director. You are relying on advice of counsel, which you're permitted to do. How much does it cost to amend your docs to get rid of Kaufman language? Mary asks. Well, you know what? We did an entire webinar on amendments and didn't mention cost. So I don't know what the hell I was thinking, but here we are. Usually for a single amendment, we're talking about 3 to 6 hours. At least that's what our firm generally charges, or at least my Orlando office of the firm. So that's really the basics of what you're looking at. And Jeff, thank you for cutting off the Q&A. I'm going to make sure to get to everything else that's already been asked, and then we'll cut it down. But yeah, Mary and everyone else, it's usually a minimum of about 3 hours to draft that amendment package. Some people will say $2,000-$3,000. There's really no reason in my mind that needs to be the cost for a single amendment. But obviously it'll go up as you increase the number of amendments that we're working on. We can also do a full review of your governing documents. That's a flat fee project, or a capped project at least. Amended and restated declarations are also commonly done. So if you need any kind of quotes for that type of work, feel free to reach out. But getting back to the Q&A, which is really what this is all about, Edith asks, does the rules and regulations need to be recorded? The answer is no. But if they're not recorded, then no one is considered to be on notice of what their content is, except for people that own in the community, rent in the community, or are entering the community. Anyone else is not going to be considered to be on notice of the content of those rules and regulations. So there are pluses and minuses. I'd run that question by your counsel.
For instance, a
Further
vendor,
guidance.
contractor is one example.
Right. Yvonne asks, how do we deal with a homeowner who's not paid dues since day and keeps one step ahead of the law? Find an attorney that's going to get aggressive about your collection. That's the best answer I can give. Christina asks, how are proxies used to obtain quorum? Must the person who's designated be present at the meeting or vote for board? Well, this is going to be a member vote when we're talking about amendments. But proxies are used to obtain a quorum because the person that gives that proxy doesn't have to physically be present. That's the whole purpose of giving that proxy, is that someone else votes on your behalf, or you vote in writing and say, "Here's my vote. Have a nice day. Enjoy your meeting." So that quorum is determined by whether or not you got enough proxies and enough people that are physically attending in person. Yvonne asked, declaring bankruptcy and keeps moving the case out of state. When it comes to collection, find an attorney that has connections outside of Florida or is willing or able to serve in different states and just get pro hoc viced in, which basically means that another attorney is vouching for them so that they're allowed to practice in this other state. Bankruptcy is pretty much the same no matter where you're practicing it throughout the country, other than certain local rules that will apply to certain jurisdictions and judges. Justin asks, if the documents currently don't allow sheds, do we need to update to allow with new Florida laws? And the answer to that, Justin, is no, you don't need to update it. You can still enforce that, but you're taking a risk that a judge doesn't understand the law or your attorney doesn't understand the law well enough to explain that that is an unconstitutional restraint on your existing declaration and your existing restrictions. So that is all of the Q&A we've got. I made it at 12:15. Thank you so much, everyone, for coming. Chuck, great
Thank you
job.
so much.
This was Chuck's first webinar for the firm. He's done a bunch before, but I think he kicked some butt. I hope everyone agrees. I
Thank you,
appreciate
Alan,
you
Jeff.
coming out.
Thank you.
If you need to reach Chuck, me, or Jeff, our email addresses will be on the materials that you're going to get. If you're actually watching, you've seen our email addresses on our pictures the entire time. And I will leave it up to you guys to, explain whatever you need to explain. I know, Jeff, you got a bunch that you need to explain for a minute. Chuck, if you have some final words of wisdom, feel free.
No, just thanks for attending. We appreciate it. That's all I have.